Hello and welcome to the Minimum Competence episode for Friday, June 13th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, Tesla suing over robot hand secrets, Trump's guard deployment seesaws in court, and the Supreme Court fast-tracking his controversial policies. Let's remember, knowing is not enough, we must apply. Willing is not enough, we must do and read today's legal news. On this day in legal history, June 13th, 1966, the U.S. Supreme Court issued its landmark decision in Miranda v. Arizona, fundamentally reshaping American criminal procedure. The case centered on Ernesto Miranda, who had confessed to kidnapping and rape during a police interrogation without being informed of his constitutional rights. In a narrow 5-4 ruling, the court held that the Fifth Amendment's protection against self-incrimination and the Sixth Amendment's right to counsel require law enforcement officers to inform suspects of their rights before custodial interrogation begins. The decision mandated that suspects be told that they have the right to remain silent, that anything they say can and will be used against them in court, and that they have the right to an attorney, either retained or appointed. These now standard warnings, known as Miranda rights, became a required part of police procedure across the United States. Chief Justice Earl Warren, writing for the majority, emphasized that custodial interrogation is inherently coercive and that procedural safeguards were necessary to preserve the individual's privilege against self-incrimination. The dissenters, led by Justice Harlan, argued the decision imposed an impractical burden on law enforcement and that traditional voluntariness tests were sufficient. Miranda sparked immediate controversy, with critics warning it would hamper police efforts and allow guilty individuals to go free. Nonetheless, it has endured as a cornerstone of American constitutional law, embodying the principle that the government must respect individual rights even in the pursuit of justice. Over the years, the ruling has been refined but not overturned, and Miranda warnings are now deeply embedded in both law enforcement training and popular culture. Tesla has filed a trade secret lawsuit in California federal court against former engineer Jay Lee and his startup Proception, alleging that Lee stole confidential information to accelerate the development of robotic hands. According to the complaint, Lee worked on Tesla's Optimus humanoid robot project from 2022 to 2024 and allegedly downloaded sensitive files related to robotic hand movements before departing the company. Tesla claims Lee used his proprietary data to give Proception an unfair edge, enabling the startup to make rapid technological gains that had taken Tesla years and significant investment to achieve. The suit points out that Proception was founded just 6 days after Lee left Tesla and began showcasing its robotic hands only 5 months later, devices Tesla says bear a striking similarity to those of its own design. Tesla is seeking monetary damages and a court order to prevent further use of its alleged trade secrets. Legal representation for Tesla includes attorneys from Gibson, Dunn, and Crutcher, while counsel for Proception and Lee has not yet been disclosed. A federal district court and a federal appeals court issued conflicting rulings over President Donald Trump's deployment of National Guard troops in Los Angeles amid protests over aggressive immigration enforcement. U.S. District Judge Charles Breyer ruled earlier in the day that Trump's order to deploy the Guard was unlawful. He found that the protests did not meet the legal threshold of a rebellion, which would be necessary for the president to override state control of the Guard under the Insurrection Act or related powers. Breyer concluded the deployment inflamed tensions and stripped California of the ability to use its own Guard for other state needs. His 36-page opinion ordered that control of the National Guard be returned to California Governor Gavin Newsom. However, about 2.5 hours later, the Ninth U.S. Circuit Court of Appeals granted an administrative stay, temporarily pausing Breyer's ruling and allowing Trump to retain command of the Guard for now. The 3-judge panel, 2 appointed by Trump and 1 by President Biden, stressed that their order was not a final decision and set a hearing for the following Tuesday to evaluate the full merits of the lower court's decision. Meanwhile, a battalion of 700 U.S. Marines was scheduled to arrive to support the Guard, further escalating the federal presence. Critics, including LA Mayor Karen Bass and Senator Alex Padilla, who was forcibly removed from a press event, argued that the military response was excessive and politically motivated. Supporters of the deployment, including Trump and DHS Secretary Kristi Noem, defended it as necessary to restore order. A Reuters Ipsos poll showed public opinion split, with 48% supporting military use to quell violent protests and 41% opposed. In a pattern that surprises few, the conservative-dominated U.S. Supreme Court has granted President Donald Trump a series of victories through its emergency or shadow docket, continuing a trend of fast-tracking his policy goals without full hearings. Since returning to office in January, Trump's administration has filed 19 emergency applications to the court, with decisions in 13 cases so far. Of those, 9 rulings went fully in Trump's favor, 1 partially, and only 2 against him. These rapid interventions have enabled Trump to enforce controversial policies, including ending humanitarian legal status for migrants, banning transgender military service, and initiating sweeping federal layoffs, despite lower court injunctions. District court challenges to these actions often cite constitutional overreach or procedural shortcuts, but the Supreme Court has repeatedly overruled or paused these lower court decisions with minimal explanation. The emergency docket, once used sparingly, has become a regular tool for the Trump administration, matching the total number of applications filed during Biden's entire presidency in under 5 months. Critics argue that the court's increasing reliance on this docket lacks transparency, with rulings frequently unsigned and unexplained. Liberal justices have voiced strong objections, warning that rushed decisions with limited briefing risk significant legal error. The court's 6-3 conservative majority, including 3 Trump appointees, has given the president a judicial green light to implement divisive policies while litigation plays out. Some legal scholars argue these outcomes reflect strategic case selection rather than simple ideological bias. Still, in light of the court's current composition and its repeated willingness to empower executive action, the results are hardly shocking. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, click a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here on Monday, and until then, note, we like to close out the week of shows with a featured musical piece. That will make these Friday episodes seem especially long. We hope you'll stick it out and enjoy the featured piece, but if music, and specifically classical music, isn't your bag, we get it. Our mouth sounds unrelated to the week's closing music ends here. This week's closing theme is by Tommaso Albinoni. This week's closing theme is Sinfonia in G minor by Tommaso Albinoni, a composer whose elegant, expressive works have often been overshadowed by his more famous contemporaries. Born on June 14, 1671 in Venice, Albinoni was one of the early Baroque era's leading figures in instrumental music and opera. Though he trained for a career in commerce, he chose instead to live independently as a composer, unusual for his time. He wrote extensively for the violin and oboe and was among the first to treat the oboe as a serious solo instrument in concert music. Albinoni's style is marked by a graceful clarity and balanced formal structure, qualities well represented in this week's featured piece. The Sinfonia in G minor is a compact 3-movement work likely composed for a theatrical performance or ceremonial function. It opens with a dramatic grave, setting a solemn tone that gives way to a lively allegro and a brief yet expressive final movement. The G minor tonality gives the piece an emotional intensity without tipping into melodrama, typical of Albinoni's refined dramatic sensibility. While his best-known composition today may be the Adagio in G minor, ironically a piece reconstructed long after his death, Albinoni's authentic works, like this Sinfonia, display a deft hand at combining lyricism with architectural clarity. His music enjoyed wide dissemination in his lifetime and was admired by Johann Sebastian Bach, who used Albinoni's bass lines as a model for his own compositions. As we close out this week, Albinoni's Sinfonia in G minor offers a reminder of the beauty in restraint and the enduring resonance of Baroque form. Without further ado, Tommaso Albinoni's Sinfonia in G minor. Enjoy.